Fitzgerald.
My Lord, you've invited me to deal with Ling, the case which is at page 846 onwards in the bundle. And as I understand it, my learned friend is citing it as authority for the proposition that the broadened purposive construction principle only applies to the entrenched human rights parts of a constitution and doesn't apply to the rest of the constitution. And can I just show the board I won't go to the head note unless you wish me to, but can I just take you to the key passage which he appears to rely on, which is...
bear with us just 1 second, please.
Has the board's got...
We received Edwards, by the way. Thank you very much.
Oh, yes.
Thank you. The main bundle page.
Well, your lordships will see at 862 at the bottom, there's an approach to interpretation of the basic law, and it begins at H. 862 H. We must begin by recognising and appreciating the character of the document. The basic law is an entrenched constitutional instrument to implement the unique principle of one country, two systems. As is usual for constitutional instruments, it uses ample and general language. It is a living instrument intended to meet changing needs and circumstances. Generally accepted the interpretation of a constitution such as the basic law, a purposive approach is to be applied. The adoption of a purposive approach is necessary because a constitution states general principles and expresses purposes without condescending to particularity and definitions of terms. Gaps and ambiguities are bound to arise, and in resolving them the courts are bound to give effect to the principle and purpose declared in and to be ascertained from the constitution and relevant extrinsic materials. So in ascertaining the true meaning of the instrument, the courts must consider the purpose of the instrument and its relevant provisions, as well as the language of its text in the light of the context being of particular importance in the interpretation of a constitutional instrument. As to purpose, the purpose of the basic law is to establish the HKSAR being an inalienable part of the People's Republic of China under the principle of one country, two systems, with a high degree of autonomy in accordance with China's basic policies regarding Hong Kong as set out and elaborated in the joint declaration. The purpose of a particular provision may be ascertainable from its nature or other provisions of the basic law or other relevant extrinsic materials. So that may be important. The context is said. As to the language of its text, the courts must avoid a literal, technical, narrow, or rigid approach. They must consider the context. The context of a particular provision is to be found in the basic law itself, as well as relevant extrinsic materials, including the joint declaration. Chapter 3 of the basic law. So far, it seems to be saying that generally in the approach to this constitutional document, you avoid the literal, technical, narrow, or rigid approach. And then, so that's, as it were, part A, and we invoke that. Chapter 3 of the basic laws begins by defining the class constituting Hong Kong residents, including permanent and non-permanent residents, and then provides for the rights and duties of the residents. What is set out in Chapter 3 after the definition of the class are the constitutional guarantees for the freedoms that lie at the heart of Hong Kong's separate system. The court should give a generous interpretation to the provisions in Chapter 3 that contain these constitutional guarantees in order to give to Hong Kong residents the full measure of fundamental rights and freedoms so constitutionally guaranteed. However, when interpreting the provisions that define the class of Hong Kong residents, including in particular the class of permanent residents, the court should simply consider the language in the light of any ascertainable purpose and the context. I was just pausing there. They do recognise that you have to look at the purpose and the context, and then they go on. The context would include other provisions of the basic law, which are obviously include the human rights provisions. Of particular relevance would be the provisions of the ICCPR as applied to Hong Kong, because it's incorporated respect for the ICCPR into the basic law by virtue of Article 39, and any relevant principles which can be distilled from the ICCPR. So that really doesn't lead to you take a strict literalist approach even to the interpretation of the citizenship provisions, because you have to look at the context, which includes other provisions of the basic law and the International Covenant on Civil and Political Rights. what we have set out above cannot and is not intended to be an exhaustive statement of the principles the court should adopt, etc. So, my lords, I would just respectfully submit, firstly, the remarks up to the break before Chapter 3 clearly indicates that the approach to a constitution as a whole is the broad and purposive approach. They do indicate there's some form of distinction to be drawn between citizenship provisions and the content of the human rights guarantees that you get once you are a citizen. But they recognise that the context would include other provisions of the Basic Law and the ICCPR. So, my lord, I don't respectfully submit that accept that this is authority for the proposition that you can compartmentalise in the way suggested the Constitution such that you simply apply ordinary statutory construction to Chapter 2 in our case, and a special different test to Chapter 3, particularly when there's the overlap that my lords have drawn attention to and that is blindingly obvious. If you're a citizen, then you have a right not to be removed, which is guaranteed under Article 25. And my lord, so that's my respectful submission in relation to Ng Ka Ling. But I did mention Edwards, an Attorney General, and again, the proposition that I'm seeking to invoke it in support of is that the special rules enunciated in Fisher, Reyes and Bowe are not confined to the interpretation of the human rights provisions. They are rules for the interpretation of a constitution as a special document, which, as my Lord Legate drew attention to, the alteration of that requires a special majority of 3/4. Indeed, the alteration of the citizenship provisions requires a special majority. So if we look at Edwards, just as this is the start of all the language of living instrument that is then, and broad and generous construction, it's back in 1930, and it was because the senator, a lady wished to be a senator, and there were provisions which suggested that the only people who could be senators were men. You can see that page 125. The qualifications of a senator shall be as follows: he shall be of full age, he shall be either netrable, he shall be legally his real, and it's all the he's, as it were suggesting that it was only men who could be senators. And you see the head note, the word person in section 24 of the British North America Act 1867 includes members of either sex. Accordingly, women having the qualifications enacted by section 20 can be summoned by the Governor-General to the Senate. So held upon an examination of the earlier Canadian legislation being inconclusive as to the intention of the Imperial Parliament, and decisions in England based upon the disability at common law of women to hold public office being inapplicable to the interpretation. So you don't invoke common law disabilities in looking at a constitution, just as you don't invoke common law presumptions about illegitimacy in this case. The provisions of the British North American Act 1867 enacting a constitution of Canada should not be given a narrow and technical construction, but a large and liberal interpretation, so that the Dominion, to a great extent, but within certain fixed limits, may be mistress in her own house, as the province, to a great extent, but within certain fixed limits, are mistresses in theirs. And then going on from there to really page 136, this is where one has the statement that constitutions develop through usage and convention. Page 136, halfway down. The British North America Act planted in Canada a living tree capable of growth and expansion within its natural limits. The object of the Act was to grant a constitution to Canada. Like all written constitutions, it has been subject to development through usage and convention. Their lordships do not conceive it to be the duty of this board to cut down the provisions of the Act by a narrow and technical construction, but rather to give it a large and liberal interpretation, so that the Dominion, to a great extent, but within certain fixed limits, are mistresses. Is mistress in her own house. The Privy Council indeed has laid down that the courts of law must treat the provisions of the British North America Act by the same methods of construction and exposition which they apply to other statutes. That's A. But, and this is B, there are statutes and statutes. and the strict construction deemed proper in the case, for example, of a penal or taxing statute, or one passed to regulate the affairs of an English parish, would be often subversive of Parliament's real intent if applied to an act passed to ensure the peace, order and good government of the British colony. And then it's citation from Clement's Canadian Constitution. The learned author of that treatise quotes from the argument of Mr. Mowat and Mr. Edward Blake in St. Catherine's Milling case. That act should be on all occasions interpreted in a large, liberal and comprehensive spirit, considering the magnitude of the subjects with which it purports to deal in very few words. With that, their lordships agree. The question is not what may be supposed to have been, but what has been said. And then it goes on. And then they'd say they're not determining question of the rights of women, but only questions to eligibility for a particular position. And the ruling at the end is that though qualifications for Senate were expressed in masculine terms in the passage which I showed you in the head note, page 143, the lordships have come to the conclusion, this is right at the bottom of 143, come to the conclusion that the word persons in section 24 includes members both of male and female sex, and that therefore the question propounded by the Governor-General should be answered in the affirmative. My Lord, I know that may be a rather long way, but given that this is the source and the origin of this whole doctrine of broad and purposive construction and living instrument, it's got nothing to do with entrenched human rights provisions there. It's about the interpretation of a document described as a constitution for reasons to do with the nature of a constitution. And that's why in Fisher they talk about the approach to the interpretation of a constitution, not just the entrenched provisions. In Ray's, Lord Bingham talks about the rules governing the interpretation of a written constitution. And in Bow again, he talks about that. So I would respectfully submit that though, of course, the language guaranteeing human rights is particularly susceptible to evolution in accordance with developing concepts of decency, etc., the principle of interpreting in a broad and purposive way applies equally to Chapter 2 here as to Chapter 3. Because the rights have been included in a constitution, and because it's going to be difficult to change those, and therefore they have to be interpreted in a way that doesn't fix with a particular historical chain, as it were, the development of the full enjoyment of rights. Well, those are the points I make about the point that made by my learned friend that you restrict the broad and purposive approach to the entrenched provisions governing human rights and not to Chapter 2 defining citizenship. And the court has already, or members of the court have already observed, and I respectfully agree, that there is overlap. There's interpenetration. If you have certain rights when you have a citizenship, then the magnitude, which is one of the tests in Edwards of what's at stake, is the same. Are you a citizen, and do you have all the rights that flow from citizenship? My lords, then, if I can return back to the question of the interpretation, I've taken the court to the point that Article 14 is distinguishable from a savings clause. I think I took you to the case of Suraj, and the fixed paragraph 80 in Suraj they talk about, which is at 812. They talk about some parts of a constitution can develop and some are not susceptible to development, such as savings clauses. Yes, that's really at page 812, the first paragraph above 81. Some provisions of the Constitution, including the savings provisions, section 6, are fixed and determinate in their effect, hence not amenable to adaptation according to the living instrument document. Or we would say...
so whereabouts on page 812, sorry?
So, my Lord, 812?
Yes.
Does my Lord see at the top of, just above 81,
right,
about 10 lines up from 81, some provisions of the Constitution.
Sorry, we're going to...
Page 812 of the...
Just one problem. A moment.
812 in Suraj.
Sorry.
You see there's a citation of a number of cases, Mirage,
I've got a
Seabasad.
technical problem just for a moment, if you just bear with me. Page 812.
Yes, my lord. At B, at the top, some provisions of the Constitution, including the savings provisions in Section 6, are fixed and determinate in their effect, and hence not amenable to adaptation according to the living instrument doctrine. But by contrast, the rights in Section 1 are not precisely defined, certainly are to be interpreted in accordance with that doctrine. And I'm respectfully...
So you say the rights in Article 6 aren't precisely defined?
Well, my lord, but my first submission, as my lord knows, is it's clear.
Yes.
But I'm saying if there is ambiguity in it, if as it were, well, I suppose the ambiguity lies in the question of does Article 14 qualify Article 6? If there is any room for doubt, I say then the broad and purpose of construction excludes that approach. My lord, I hope so. I am saying it's clear, and we don't need broad and purposive, and that's because it refers to biological parents, and the only requirements are that you're born, a physical objective fact, and that one of your parents is one of your biological parents is a citizen, and I say it's clear. But if there is ambivalence as to whether Article 14 bites on Article 6, then a broad and purposive construction would say no. And not just that, there's a corollary of the broad and purposive construction, which is that whenever you get something like Article 14, which restricts rights, that has to be given a restrictive definition. And that's the corollary of the Fisher approach is a provision like Article 14 that restricts or limits rights should be given a restrictive interpretation of its ambit. And that's, I think I galloped through it, but can I just show you the case of Hughes in our supplementary bundle at page 48, so the Respondents supplementary bundle at page 48. This was a savings clause being given a restrictive definition contrary to Suraj. Since this is at page 48, paragraph 35, since paragraph 10, there was a prohibition on cruel and unusual punishment.
Page 277 internally.
No, page 48, my lord, of the...
48.
Yes.
Right.
So I'm saying, I see, yes, your lordship's quite... Yes, 277 up at the top, yes.
And paragraph?
Yes. 35.
Thank you.
Just to introduce it, it was you can see the text of paragraph 10 at 277B, my lord. Nothing done under the authority of any law should be held to be in contravention of section to the extent that the law in question authorised the infliction that was lawful in... And they give it a restrictive interpretation to that paragraph 10 because it introduces exceptions to the rights and protections which people would otherwise have under the Constitution. It must be construed like any other derogation from constitutional guarantees. And then it cites in State and Petrus is another well-known principle of construction that exceptions contained in constitutions are ordinarily to be given strict and narrow rather than broad construction. My lords, I would submit that to the extent that Article 14 if it were a candidate for limiting the broad right in Article 6, then it would fall into that category of something restricting rights, and it should be given a strict and narrow construction, and therefore, unless it's absolutely clear that Article 14 does bite on Article 6, it shouldn't be relied on.
I'm afraid I haven't got the actual quotation you referred to. Page 48, letter what, sorry?
Okay, I'm so sorry. Page 48, paragraph 35. Does my lord?
Okay, yes.
Does your lordship see that? Since paragraph 10 introduces these exceptions to the rights which would otherwise be under the Constitution, it must be construed like any other derogation from constitutional guarantees. State and Petrus, Aguda Justice of Appeal, observed that it is another well-known principle of construction that exceptions contained in constitutions are ordinarily to be given strict and narrow rather than broad construction. In case...
Rather beg the question as to whether it is a constitutional guarantee.
Yes, my lord, but this...
The relevance is not, is it, that there's some presumption in favour of people being citizens? That can't be right. It's that there's a presumption against people being treated differently because they're illegitimate.
Yes, my lord, yes, that would be it. I mean... That's
the constitutional element,
yes,
where you bring in values of other parts of the Constitution.
Yes. To the extent that that article, to the extent that it's supposed to be Article 14 is supposed to be, as it were, limiting Article 6, the right conferred by Article 6, and excluding illegitimate children from benefiting from their fatherhood, we would say that principle is in operation. And certainly the way that it was put by Chief Justice Winder at paragraph 33 was you'd need very clear words to justify the interpretation advanced. So he puts it at page 84.
Which is the discrimination part of the Constitution?
Oh, my lord, Article 15, and I think it's 11 too, but my lord, Article 15 of the Constitution prohibits discrimination, and whereas every person is entitled to fundamental rights, that is to say, has the right, whatever his race, place of origin, political opinions, subject to the respective rights.
I'm not sure it's going to help you directly, is it? Because it's only talking about discrimination of certain kinds. And
Article 26, my lord, at page 575, takes this further. Protection from discrimination on grounds of race, etc. Subject to the provisions of paragraph 4.5, no law shall make any provision which is discriminatory either of itself or in its effect. So that's as it were the major proposition, discrimination. And then
Article 26.
26.1, my lord, at page 575. Does my lord have that?
Yeah.
So subject to the provision.
May I do it in 26.1.
Yes.
So if the legislature has got a restricted power to make laws, then you say the Constitution should be interpreted in the same way?
My lord, yes.
Subsection 3 as well.
And then, yes, my learned friend, right, in this article, the expression discriminatory means affording different treatment to different persons attributable wholly or mainly to their respective descriptions by race, place or origin, political opinions, colour or creed, whereby persons of one such description are subjected to disabilities or restrictions to which persons of another such description are not made subject or are accorded privileges or advantages. So that would be both children of a Bahamian father, but one is born within wedlock and one is not. So in every other respect, they're the same. And
so it's not restricted to race, place of origin, political opinions, colour or creed?
No, and my lord, if we look at 26.1, no law shall make any provision which is discriminatory either of itself or in effect. It doesn't then say, and that means...
I think it does, Mr. Fitzgerald, I think it does.
26.3 definition.
That's exactly what it says.
Oh, yes, well, or yes, I see, but it's...
That's why I asked you to read it.
No, I don't think we can get place of origin. No.
There are lots of laws that are...
That's why... Well,
lots of laws are discriminatory.
yes. Well, my lord, there is, in 15, there is the overall statement, race, place of origin, political, was subject to, so fundamental rights is entitled to fundamental rights, that is to say it has the right whatever is race, place of origin, political opinions, colour, creed or sex, but subject to the respective rights of others. Yes, that doesn't have other status, which is of course what is. But it does have the protection of law, and the language of the protection of law has been interpreted to extend to equal treatment for equal cases.
And where do we find the protection of law?
That's in 15.1. 15A. So, whereas every person is life, liberty, security of the person, and the protection of the law. And there is now authority, certainly from the Caribbean Court of Justice, that the, as it were, the preambular or prelude sections, such as section 15, do confer specific rights. It's in a case called Nerval. Nervais.
And the protection of law in this case then is what?
The protection of law would mean protection of law from arbitrary distinctions, and of course that would develop with the course of time.
Depends upon what the Constitution says, doesn't it?
What?
That depends on what the Constitution says.
You mean you'd have to interpret that in terms of what is said in Article 26? Is that what?
Well, it depends on the protection of the law in relation to citizenship, and that then depends upon Article 6.
Well, my lord, there is a body of case law which says where you use the language of law, you're not just saying subject to enumerated law, but to a law that is not arbitrary. In other words, wherever the word law appears, it carries with it the notion of certain fundamental principles, such as non-discriminatory treatment. So, my lord, I accept that that it's more specific in Article 26 than in Article 15, but the protection of the law would be wide enough in our submission to protect you against something that was arbitrary, which would now be considered arbitrary, because this would be a developing principle, such as a discrimination on grounds of illegitimacy. In other words, protection of the law is not just, well, then you look to see which law is being broken. It contains a notion of law which is non-arbitrary. That goes right back to the case of Omar Chuan, where Lord Diplock said, whenever you have the word law in a constitution, it means a system of law which is non-arbitrary.
Even if you can't point to anything specific in the constitutional rights, it's a more general point, isn't it, that given this is a constitutional document,
Yes.
you shouldn't read it in a way which introduces an arbitrary distinction if you don't have to.
Yes. Perhaps that's. I'm sorry if I've gone on yes, and that's what Chief Justice Winder says at paragraph 33, EB 84, where he says. That's at paragraph. Yes, he says, unless I've got to. Yes, he says, yes, he says, it's at paragraph 33, page 84, halfway down. In a constitution which advances fundamental rights and equality, an interpretation which avoids inconsistency with these rights must be preferred. If the establishment of such an anomalous and unfair regime was intended, that's the broader point, an anomalous and unfair regime was intended, one would have expected clear, direct words to that effect, not the artificial and strained interpretation contended for by the respondent. That's of reading in what he called the indirect effect of applying Article 14 to Article 6.
Is it any part of your submission, I think you mentioned this before, that the position prior to the Constitution was that illegitimate children born in the Bahamas had citizenship.
Yeah, yes, my lord. And
In some sense, it might be an aspect of what you're now talking about, which is that you don't want to give an interpretation, or if possible, one would err towards an interpretation that would not replicate, not take away rights that would otherwise have been afforded to illegitimate children born in the Bahamas.
Yes, or the principle, yes, my lord, just building on that, the principle that you don't take away a right except for by a vested right except for by clear language. I think, just so that you have it, in the judgment of Evans, yes, he actually sets out for, which is helpful, at paragraph 243, the position that was the position before, just to underline that point. Paragraph 243, page 212, there would be no issue if Article 6 had ended with the words date of his birth. In this regard, it is interesting to note that Section 4 of the British Nationality Act was in these terms: citizenship by birth. Subject to the provisions of this section, every person born within the United Kingdom and colonies after the commencement shall be a citizen of the United Kingdom and colonies by birth. So he sets out Section 4 of the 1948 Act. And then commenting on that, 245 at page 214, it is significant, therefore, that between 1949 and 1980, birth in the UK or Crown Colony was sufficient in itself to confer the status of citizen of the United Kingdom and colonies, regardless of the parent's status. The attainment of citizenship by descent was not made applicable to persons born within a Crown colony. There was a clear separation between citizenship by virtue of birth in the Crown colonies and citizenship by descent from someone born in the Crown colony. And then it was during this period that the Bahamas Constitution was promulgated. It's therefore a cause for concern that a person born in the Bahamas, a Crown colony, prior to 1973, would by his birth be entitled to citizenship. But after 1973, a person born an independent Bahamas would not enjoy the same right. This is especially so since the purpose of constitutions is to preserve rights and not to take them away. And then he says, however, it is clear that the framers of the Constitution chose to remove the entitlement to citizenship based on birth alone, but instead in Article 6 combined birth in the Bahamas with descent. So, yes, so you now get descent, but then let's not, as it were, limit descent to only those in a married relationship. And can I just show you, because it's clear that Justice of Appeal Evans his judicial conscience is troubled by what the position is at paragraph 260, EB 218. So should we continue to construe the Constitution consistent with an archaic system which allowed men to shirk their responsibilities to children whom they fathered and left children without at times the benefit of parental care? A constitution is intended to provide a formula for the peace, order and good government of a nation. It must be construed consistent with that aim. Does it mean the same thing as it did back in 1973? If the answer is yes, then it is unfortunate, because the entrenchment of clauses which were intended for the protection of people have proven to be a millstone around the necks of the very people who it was intended to protect. With each failure by our people to appreciate the need for adjustments, we are adversely affected. So he's saying if you can possibly avoid this conclusion, you should, but then unfortunately he then concludes you can't. And so he finally concludes that the words are so clear that, but we've just looked at with my learned friend and in his interchanges with my lord, it's quite clear, it's absolutely clear that there's no ABC answer in favour of the restrictive interpretation. You can't simply say it's plain as the light of day that Article 14 applies to Article 6. We say it's plain that it doesn't. But nobody in their right minds could say, as the President says in this case, it's absolutely clear. It's unreasonable to conclude the other, after Chief Justice Winder has spent a series of well-reasoned paragraphs explaining why there's no reason why Article 14 should bite on Article 6. And so we do submit, therefore, if there is, we say it's clear.
Unfortunately, it's in the nature of judicial reasoning that you get different judges with opposite views saying that their position is the only clear possible interpretation.
Well, I know, my lord, but now standing back, we are able to say, I would respectfully submit, at the very least, nobody could say, given what the Commission says, given the massive difference of judicial opinion, that this is clear cut. And if it's not clear-cut, what is the principle that applies? It's that you adopt that construction which least restricts human rights or least restricts the right to citizenship. And so, my lord, we say, first of all, Chief Justice Winder was absolutely correct. And if I can be absolutist on this, there is only one interpretation. But if there isn't, if there is some room for doubt, then ambiguity as to whether Article 14 bites on Article 6 should be resolved by having regard to the massive effect. I think President Barnett says it affects tens of thousands of people. I think actually he may have got that from a press release from one of the, but in any event, it obviously does affect a lot of people, so my lord, that is the reason. And then that brings me on to the international law, and we may have rather inelegantly pleaded our case by relying simply on the convention. But can I, because it is important, because there are a number of Caribbean countries, including Belize, whose position is analysed in the Reyes case, that have signed up as members of the Organization of American States to the Declaration. So they're bound in international law by the American Declaration of Human Rights, which my learned friend has provided a copy of, which is in broad terms, but they haven't signed the convention. And the position of those countries is looked at in the Edwards and Bahamas case, which says you may not have signed the convention, the American Convention on Human Rights, which is the later specific provision, but you have committed yourself to respect for the American Declaration by virtue of your membership of the OAS. And if you look at paragraphs 107 to 108, Electronic Bundle 1164, the position is there dealt with. So Bahamas, like Belize and a number of other, I think Antigua, other jurisdictions, are bound by the American Declaration, but not by the American Convention. The 107, the Commission will analyse the merits of Edwards, Hall's, Schroeter's and Bolig's petitions pursuant to the provisions of the Articles of the American Declaration. So you're bound by that if you're a member of the OAS, because Bahamas is not a party to the American Convention. In addressing the allegations raised by the petitioners' representatives in these cases, including their claims that the condemned men's mandatory violate Article 1 of the American Declaration, the Commission first wishes to clarify that in interpreting and applying the Declaration, it is necessary to consider its provisions in the context of the international and inter-American human rights law
You're reading
systems.
which paragraph, Mr. Fisher?
Paragraph 107.
107, thank you.
Does my lord have?
Yes, I do. Thanks.
So it's the Commission wishes to clarify, my lord, that in interpreting and applying the Declaration, it is necessary to consider its provisions in the context of the international and inter-American human rights systems more.
What does the Declaration say?
The Declaration, I'll show you, you've got it in the supplementary bundle, my lord. It doesn't expressly prohibit. So you've got it in my learned friend's supplementary authorities. But what we rely on there, can I just finish that for one moment, my lord? So you have to have regard to the other things, and there's a footnote 46, which your lordships will see a little bit further on. which says you've got, page 1183, the Canada report, confirming that while the Commission clearly does not apply the American Convention in relation to member states, its provisions may well be relevant in informing an interpretation of the principle of the Declaration. So now let's look at the Declaration, which is in my learning friend's supplementary bundle, and we have Article 2, which prohibits discrimination on any other grounds, on grounds of status. So tab 5, page supplemental bundle, page 396. Page 396.
Thank you.
EB 396. So the declaration which they are bound by contains Article 2, right to equality before the law, and the board will see all persons are equal before the law and have the rights and duties established in this declaration without distinction as to race, sex, language, creed, or any other factor. So that's the or any other status, which includes illegitimacy. Article 6, every person has the right to establish a family, the basic elements of society, and to receive protection, therefore. And you've seen the European Court cases defining family rights to include the rights to the family relationship with those who are not married in, not the product of a wedlock union.
Gerald, you couldn't just bring me through it again. This declaration,
Right.
Has the state joined up, signed up to it?
Yes.
Right.
They're bound by the declaration, and that's what Edwards and Bahamas says.
Okay.
If you're a member of the OAS, by virtue of membership of the OAS, you commit yourself to respect the declaration. And that's why in the Inter-American Commission, they didn't turn up and say, you can't look at our conduct. They did, and the Commission did look at their conduct because but they judged it by reference to the declaration. And Edwards and Bahamas is cited in Ray's, I think, and then you see Article 6, family, Article 8, the right to residence. Every person has the right to fix his residence within the territory of the state of which is a national, to move about freely with it and not to leave it except by his own will. Then you have Article...
What do they mean by any other factor?
That similar language is, or any other status in the European Article 14 has been interpreted to mean no discrimination on grounds of illegitimacy. In other words, when you have or any other status, that covers same-sex relationships, it would cover illegitimacy. So once you've got or any other factor, you've got the, as it were, add-on of it's not just race, sex, language, creed, but also any other factor. So they are bound as a matter of...
You're using the European Convention on Human Rights in order to interpret this declaration?
Well, I'm using their own case law to interpret it, my lord, which... I mean, there's a consistent body of case law in which they've said any discrimination on grounds of illegitimacy is outlawed.
But you can bring in, according to what you showed us, the American Convention on Human Rights to determine, to inform the interpretation, even though they're not parties to it.
That's right, and Article 17, because it's as it were, a development of these rights that they are committed to. And 17.5 says you absolutely prohibits discrimination on grounds of illegitimacy. 17.5 of the Convention. So, my lords, that's that, and then you can see the right to nationality, which my learned friend has helpfully highlighted. But page 400, every person has the right to nationality to which he is entitled by law, to change it if he so wishes for the nationality of any other country that is willing to grant it to him. Now, my lord, the non-discrimination provision and the family law provisions then have to be interpreted, which are binding. They have to be interpreted in the light of how those forms have been, those principles have been, as it were, elaborated in the Convention. And Edwards and Bahamas, and I've shown you the passage, establishes the rights guaranteed by the Declaration must be interpreted in the light of the more specific provisions of the American Convention, and in the footnote, which may be considered to represent an authoritative expression of the fundamental principles set forth in the Declaration. That's in footnotes 46. So then
17.5, Mr. Fitzgerald, is which page?
525, my
Thank
Lord.
you.
So 525. So if you go to 525, yes, you've got 525. So this is the American Convention, and you'll see under Article 17, rights of the family, that the law shall recognise equal rights for children born out of wedlock and those born in wedlock. So that's an absolute provision. And
So Article 3.2 and Article 8 of the Constitution don't comply with that.
no, they don't.
Yeah.
But you've got to do the best you can. The fact that you'll never be totally compliant doesn't mean that you don't try to be as compliant as possible, and that's what Neville Lewis says. That Neville Lewis says that the court shall try so far as possible to ensure that domestic law or the interpretation of the Constitution complies with the rights that you're committed to observing under the Convention. So should I? My Lord, I don't think there's anything else I should take you to. The Article 17.5 is obviously very categorical, and there's a number of cases which we've cited in our case where any discrimination on grounds of illegitimacy has been struck down by the Inter-American Court, and there's an advisory opinion on that.
Mr. Fitzgerald, this is my fault entirely. Where do we see that the Declaration is to be interpreted in the light of the Convention?
In footnote 46 to Edwards in Bahamas, and in paragraphs 107 and 108 of Edwards in Bahamas.
Thank you.
And my Lord, paragraph 108, page 1164, developments in the corpus of international human rights law relevant to the interpretation and applying the American Act may in turn be drawn from the provisions of other prevailing international and regional human rights. This includes, in particular, the American Convention of Human Rights, which in many instances may be considered to represent an authoritative expression of the fundamental principles set forth in the American Declaration. An authoritative expression of the fundamental principles set forth in the American Declaration. And then it takes you to footnote 46, which is the case of Canada. And the case of Canada, which the board, we have to look at footnote 46. Yes, at 1183 at the bottom, CEG Canada report, Supra para 38, confirming that while the Commission clearly does not apply the American Convention that have yet to ratify, its provisions may well be relevant in informing an interpretation of the principles of the Declaration. So if you're interpreting the prohibition on discrimination, which does bind Bahamas, you have to interpret that in the light of the greater elaboration of that principle of non-discrimination so far as it is reflected in the American Convention,
Which they haven't signed up to.
Yes. Well, my Lord, I accept that, but and you may say, well, this is a broad and purposive approach by the American court, but that is law, my Lord, I respectfully submit. I mean, what? I think, can we just check in Ray's? I think in Ray's, where Belize was in the same position, but Lord Bingham nonetheless cited cases from the Inter-American Commission. I mean, Belize is exactly the same position as Bahamas. I admit.
Well, you can rely on even without the convention, Human Rights Convention, you can rely on the Declaration.
Yes.
Anyway, can't you?
Yes, absolutely.
Various levels of it.
Yes. Yeah, my Lord, absolutely. And so I just simply say, so when my learned friend says the momentum of international law is neither here nor there, the answer is that's not correct. one must strive so far as possible to interpret domestic law so as to comply with obligations under the Declaration, and you can interpret the prohibition of discrimination on grounds of any other factor so far as possible to prohibit this particular form of discrimination. My Lord Stevens is absolutely right to say, well, you'll never achieve total compliance because even if you adopt our interpretation, there will be other aspects which are inconsistent with the provisions of the Convention. But it's a massive step in the right direction. And can I just, my Lords, can I just show
you don't have to do too well on this point, because you're not trying to read something out of the Constitution. You're just trying to stop being read in some 19th century rule that an illegitimate person is not a person.
Yes, my Lord. That's quite right. It's a defensive. Don't do it because of the principle in Hughes. Don't do it because of the principle in that you don't read it. Don't do it because of the principle of the Chief Justice. I would need clear words before I take this step. And don't do it because it risks further exacerbating inconsistency with the American Declaration. But my Lord, can I just show you one more thing? Because it's right to say that this principle of striving to conform with international law in the Caribbean constitutional context is dealt with in Neville Lewis, and it's right to say that in that case we were relying on something in the convention itself, although I think Jamaica then pulled out of the jurisdiction of the Inter-American Court. But can I just show you EB 750? So to put this in EB 750 above, it says there, but in addition, Jamaica, does my Lord have that at F? The words, but 750 at the bottom, F, but in addition. Jamaica ratified the American Convention on Human Rights, and it is now well established domestic legislation should, as far as possible, be interpreted so as to conform to the state's obligations under such a treaty. Well, we'd say that the American Declaration is also binding in international law, and one should seek to conform to the state's obligations under that. My Lord, in the case we have developed references to the case law of the European Court and of the Inter-American Court more, and to show the relevant momentum in international law.
We have those.
Yes, my Lord, and we've also
17.
referred to page 515 to the jurisprudence of domestic courts. Can I just draw attention to the third of those? We obviously rely on the case of Bay in the Constitutional Court of South Africa held customary law of male promulgation discriminates unfairly against children born outside of marriage.
What page?
It's page 515, my Lord, at paragraph 20. So that's the Bay case, then the Weber case, and then finally the Ogier case. That's quite significant because it's somewhat similar. The Canadian Federal Court held that the denial of citizenship to a person born outside of marriage to a Canadian father and non-Canadian mother reflected a demeaning and prejudicial view of his worth and infringed his right to equal treatment. So that there are analogies, and we would respectfully commend the reasoning of the Canadian Federal Court to the board. Yes, well, my Lord, and I think you have our submissions about the Court of Appeal that though they formulated the test in, well, Justice Bill Crane Scott formulated the test wrongly at the start, she ended up applying correctly what she thought was the true construction, and the same is true of Justice of Appeal Isaacs and Justice of Appeal Jones. So, as it were, there can be no doubt that it was their view that this was the right interpretation. And my Lord, I accept that in the end of the day, it's for the board to decide now what is the right interpretation, but it's of assistance that both the Chief Justice and three of the judges in the Court of Appeal took this view, and that one of the dissenters, as the court will now have seen, did so with deep regret that he felt driven to that conclusion, which we say he wasn't, in fact, and commented that it was inconsistent with the basic object of the Constitution to protect rights, and that it was plainly discriminatory. So, my Lords, unless you absolutely have to, and we say that far from it, you don't have to at all, it's plain in our respectful submission that it would be wrong to strain to apply Article 14 indirectly to Article 6, or to accept my learned friend's submission, which actually is slightly different from the way it was put initially in the Hall judgment, but the K judgment. But my learned friend's submission is, parents is a term of art. It means parents in wedlock, and therefore children born out of wedlock are meant to be excluded. As the courts observe, that just doesn't work. It just doesn't work, because every person, I mean, some of the children born out of wedlock do qualify, even on the interpretation put forward by the dissenting minority. So, my Lords, we say every person born in Bahamas means every biological child of a parent who has Bahamian citizenship, and provided you were born in the Bahamas and you are the biological child of a parent, one parent in Bahamas, then you qualify both on grounds of birth and on grounds of heredity. I think that's it, my Lord. But I'm obviously, if there were any matters that I could assist on.
Thank you, Mr. Fitzgerald. We're very grateful. Roe.
My Lord, it's the customary boast of the common law courts that our process of oral advocacy at some length allows arguments to be considered and refined in the course of submissions, and I hope in what I have to say in reply to demonstrate to some extent that that's right. And I'll come back to this point in a bit, my Lord, but just to flag it up in advance, I accept that it would be to go too far to say, indeed wrong to say, that in the eyes of the Constitution, a person born to an unmarried couple has no parents. And I accept that I can see the criticisms of that were advanced in the course of the argument. But that doesn't detract from the fundamental tenor of my submissions, and I'll come on to explain shortly why that is. But before I do that, my Lord, it's helpful in my respectful submission to really clear out of the way, because in my submission that's what should be done to it, the arguments about interpreting Chapter 2 of the Constitution consistently with, as my learned friend puts it, the basic tenets of the Constitution, and equally to clear away the proposition that you should interpret Chapter 2 of the Constitution consistently, in some respect, with the American Convention or with the American Declaration as interpreted by the Commission looking at the terms of the Convention, which I think was my friend's submission. So dealing first of all with the point about interpreting Chapter 2, as you're invited to do, consistently with basic tenets of the Constitution. I'd pick up that phrase from our learned friend's case. I do respectfully submit that on the authorities, it is really only constitutional provisions. In other words, in the sense, constitutional provisions in the sense of provisions about the protection of fundamental rights, which call for this special approach of broad and generous construction and so on and so forth. And the authorities that my learned friend cited to your lordships in support of the contrary proposition don't, in my submission, have that effect. The passage from Reyes, to which my learned friend took your lordships, in fact, I submit, shows the board confining its attentions there to to the question, what is the proper interpretation of the fundamental right, rather than simply saying, because it's in a constitution, we can adopt a broad and generous construction. And one sees that specifically, my lord, if one looks at page 774, I've got my reference right, in the electronic bundle, para 26, in the board's judgment as given by Lord Bingham, whereas here an enacted law is said to be incompatible with a right protected by a constitution, the court's duty remains one of interpretation. But then his lordship goes on to talk about the generous and purposive interpretation. And it's true, of course, that the board says through Lord Bingham it doesn't treat the language of the Constitution as if it were found in a will or deed or charter party, but at letter E, his lordship went on to say a generous and purposive interpretation is to be given to constitutional provisions protecting human rights. And
the trouble I have is that even if we were dealing with a will or any statute, I struggle that today you would start by interpreting it as when it refers to a child, it only means a legitimate child.
That, my lord, goes back, I think, to the necessity of refining my case as put in opening. But to the extent that that's the lordship's, to the extent that point comes up, I mean, I think perhaps I'm agreeing with the lordship. It doesn't turn on this. It doesn't turn on looking at Chapter 2 in the light of Chapter 3 of the Constitution, the fundamental rights provisions. So that's Ray's. Bow is also a case.
Citizenship, an important right in itself.
Of course it is, my lord, but so is the right to vote in elections, so is the composition of the legislature, so is the whether you have a right of appeal to the Court of Appeal or to His Majesty in Council, and so on what grounds. There are lots of different provisions which do not lend themselves to being read in a broad and purposive way.
And similarly, if we were dealing with the right to vote, we would. What's the point? Isn't it any of these important rights, citizenship, voting, whatever? You don't start with some presumption that if you're illegitimate, you don't get the right. I mean,
that's the point. I'll come back to.
You've got to be up to date to some extent.
That's my lord. Well, I'll come back to it. That's why I seek to formulate my case a little differently, so as to accommodate that objection. But can I just sticking for the moment on my learned friend's way of putting it? I think my learned friend refers to Bow as well, which is in his supplementary authorities. Again, there one it's pretty clear in my submission. One was concerned with the court was concerned with, the board was concerned with construing provisions of the fundamental rights provisions, rather than simply saying, well, because it's in a constitution, different rules apply. And it is stepping back. It would be rather odd if just because something's in a constitution, you junk all of the usual rules about how you interpret provisions. That's not to say there isn't scope for argument about what those usual rules are, and I'll come back to that. But it's not right to say just because it happens to appear in the constitution, you take a totally different approach. And we can see in Bow, I won't go to that there now, but I submit you can see clearly that is all referring to fundamental rights provisions. Chandler is the case that really makes the point, I submit, most clearly in this context. That's back in the main bundle. And the reference I wanted to go to, I think this is also plunging into the middle of the case. It's paragraph 22 at page 612 in Chandler. This, of course, as your lordship know, is the recent case about the savings provision. 22. And the board is there summarising the decision of the majority in the earlier iteration of this same argument that had taken place in Matthew and in Boyce. And paragraph, around about letter H in paragraph 2 makes the point. As the text of the Constitution is a living instrument, judges in performing that task may have to re-examine periodically the application of the provisions of a constitution to contemporary life, but not all provisions in a constitution allow themselves to be adapted to changing attitudes and changes in society, as the broadly worded statements of fundamental rights do. Some provisions are concrete and specific, and a savings clause that protects existing laws is one such provision. And that in my submission, is the real distinction. It's not actually where in terms of the typography of the document, the thing appears. It's what's the nature of the provision. Is it a provision which uses broad general words so as implicitly to require every succeeding generation of judges to put flesh on the bones, and necessarily to do so in the light of their own understanding about social standards? This goes back to what Lord Hoffman said in the Oakley case that I cited before the short adjournment, when the classic instance, of course, when a statute says you shan't inflict cruel and unusual punishment or inhumane treatment, that necessarily requires contemporary judges to say, what do we think is cruel and unusual, rather than as plenipotentiary.
Several, you've got the problem the other way around here, because it starts off with the broad general words about person, either parents, and you want to read into it the values of the 19th century in order to restrict the words.
Well, we
don't need to update them.
What I seek to do, is to, and I will come on to what I say about this in a moment. But what I seek to do is to simply to read that, but not in a way which requires the board to bend the definition so as to comply with human rights provisions. I mean, I agree. The argument your lordship's raising is it's a different point. It's about what's the ordinary construction of it, and I accept if I'm wrong about the ordinary construction, then it's really irrelevant whether my friends are right or wrong about saying let's look at the fundamental rights provisions or let's read the chapter 2 itself in a broad and generous way. It doesn't matter. But that's a separate issue which I would respectfully just want to postpone for a few minutes, if I may. There is, I've already said this in my opening submissions, but I would respectfully reiterate it. There is, I submit, real danger in seeking to read citizenship provisions as if they were in some general way subject to the fundamental rights provisions, because by their nature, citizenship provisions, that is to say who is and who is not a citizen, are discriminatory in the ordinary sense of that word. They have to draw distinctions between who is and who isn't allowed to be a citizen.
Well, they do, but there are certain grounds, such as birth or affiliation with the country, that are rational grounds, as it were. And then there are other grounds on which it's arbitrary and would be regarded as a constitutionally inappropriate ground unless you're forced to come to that conclusion.
Well, that's to get that in my respectful submission. That probably is to get ahead of the real task if one's looking at this part of the argument, which is to say what are the fundamental rights that are engaged here. And this is where my learned friend's argument breaks down to some extent, because when I think it was Lord Stevens who pressed my learned friend to say, well, what actually are the specific provisions of the fundamental rights chapter that you say are infringed by the appellant's reading of chapter 2? My friend said, well, Article 15 and Article 25. But there are some serious difficulties about that. The first difficulty...
Could you help me about Article 25? Because it refers to persons. It begins with persons.
Yes. Well, can I do Article 20? Article 25
is tie in with your concept of illegitimate children not being a citizen.
No. It's well. For present purposes, can I just indicate my submission is I don't say that all illegitimate persons are not citizens. I stand by the way we put it in our case, which is that the correct interpretation is that where Article 6 refers to parents, it means, rightly or wrongly looking at it from a moral perspective, it means mother or father if married to the mother. And I'll come back, if I may, to try and make that.
But it really all turns on Article 14, then, doesn't it?
It
you
turns
can't
on
bring
how...
in some kind of general presumption that you read,
I'll seek
or are you still trying to do that?
I'll seek to do so in a modified form in a bit, my lord, if I may. But I do just want, if I can, to try to clear this other material, as it were, out of the way, if I'm right about this. Article 25 of the Constitution, which you can find at 574, deals with the right of freedom of movement. No person shall be hindered in his enjoyment of his freedom of movement. And it's not my case. It's not my case that a child of an unmarried couple is not a person for these purposes.
Yeah.
I accept, but what Article 25
That's
does?
moving away from Galloway and Galloway, isn't it?
Oh yes. Well, Galloway and Galloway goes back to the fundamental, as it were, the common law, filius nullius.
Well, even in Galloway, Viscount Symonds was on the losing side, and that was in 1956.
Well, quite. But what Article 25 does is simply to say that no person shall be hindered in his enjoyment of his freedom of movement. And that has a perfectly obvious and sensible exception in Article 2, paragraph 2, D, that it doesn't affect restrictions on the movement of residents within the Bahamas of any person who's not a citizen of the Bahamas, or the exclusion or expulsion therefrom of any such person. Obviously, because otherwise anybody would be able to pitch up in Nassau and say, I know I'm a citizen of Argentina, but I've got this right to not to be inhibited in my freedom of movement. So it doesn't help you with the question of who is and who is not a citizen. My learned friend says, oh, well, Article 15 helps
But it does emphasise, correct me if I'm wrong, it does emphasise that if you're not a citizen, you don't have the constitutional right of freedom of movement.
Oh, of course, but that merely underscores the point that it's rather important to know who citizens are and who are not citizens.
Yeah.
But it doesn't help you with it's got no, as it were, sort of normative content as regards who a citizen should or shouldn't be. But if we go back to Article 15, there are two difficulties with Article 15. The first...
Just going back to your earlier point, isn't that an important constitutional right? That is freedom of movement.
It's an important constitutional right, but it's got to be looked at on its terms, and it's not a constitutional right that extends to persons who are not citizens of the Bahamas, to the extent that they are being excluded or expelled from the Bahamas on the basis of their non-citizenship. That's what the Constitution itself explicitly says. And one can't, in all of this constitutional adjudication, simply take the bits that favour a liberal interpretation of human rights and ignore the stuff that doesn't, and that's part of it that doesn't. The difficulty with Article 15, there are two difficulties. The first is that it doesn't apply to an unlimited or open class of types of discrimination. It doesn't, in other words, it doesn't contain the or other status provision. There's a closed list in Article 15. Race, place of origin, political opinions, colour, creed or sex, and that's it. There is, unless I'm mistaken, and maybe I'm wrong and my learned friends can either tell me now or challenge this in a post-hearing exchange, if your lordships will permit it. But unless I'm mistaken, I think it's also right to say that the board has held that Article 15 is in fact merely preambular in nature. And the case I've got in mind is a case called Newbold. It's not in the
15 itself is preambular.
It's preambular because
because the argument that was made, there probably is some law on this, is that it's not just dealing with whatever is race, etc., but every person in the Bahamas has the right to the protection of the law, and it suggested that that involves some concept of non-arbitrariness.
Yes, the problem with the argument is that in order for Article 15 to have that effect, or to be even arguably capable of having that effect, it has to be a section which confers a positive right on which you can sue, as opposed to being merely an introduction to the rest of the provisions. If you look at the way it's drafted, Section 15, whereas every person is entitled to, etc., 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 the subsequent provisions of this chapter shall have effect.
Yeah.
And the point is, and the controversy has been, is that merely a sort of preamble to the substantive rights are the ones in the next sections. And I may be wrong, and it may have been, the board may have changed its mind since, but in the Newbold case in 2014, this is, for your lordship's reference, it's not in the authorities that we can send it in, or it can be obviously readily found nowadays. It's 2014 UKPC 12. What was said there in answer to that submission was this. In short, and my learned friend will be forgiven for forgetting this because it was 9 years ago. In short, Mr. Fitzgerald's submission does not only run counter to the natural meaning of Article 15, it also ignores the word whereas and the recital in Article 15 that it is the subsequent provisions of this chapter which shall have effect.
Nervais reverses that.
Well, my learned friend says Nervais reverses that, but Nervais, of course, is not a decision of, of this board, so I'm not sure lordships are obliged to follow decisions of the Caribbean Court of Justice saying that the lordships got it wrong. So, so in relation to the Bahamas, that's as I understand it, the law as things stand.
And the paragraph reference?
It's 33. It goes on to say, if Article 15 had been understood as an independent enacting provision, the constitutional right of redress would have been extended to it. And the point there is that Article 28 of the Constitution actually tells you what you can do if you're complaining that your rights have been infringed. Not the only thing you can do, because you can also make arguments about construction, but you can go to court. But it doesn't include complaints about breach of Article 15. That's because Article 15 is just a preamble. So those are the two fundamental difficulties with saying, well, let's look at Article 15. One, it doesn't anyway contain a prohibition against discrimination on the ground of parental, marital, or non-marital status. And two, it's not anyway a provision that in itself has more than preambular effect. See the decision in Newbold. So, my lord, well, that doesn't assist, and one is then left with saying, well, yes, but look at the basic tenets of the Constitution, whatever that means. But there aren't any basic tenets of the Constitution divorced from what the Constitution actually says. So you're driven back to looking at what the Constitution itself actually says. My lord, so far as the international element is concerned, in my respectful submission, it would be highly unorthodox for the board to say, in agreement with my learned friend's submission, that although the Bahamas did not decide to accede to the American Convention on Human Rights, nevertheless, it is to be taken effectively to have done so in the sense that the American Declaration of the Rights of Man, 1948, by which it is bound, has been said by the Inter-American Commission in some sense to find expression in the American Convention on Human Rights. The short answer is that if the government of the Bahamas had intended that the people of the Bahamas at the level of international law was to be bound by the American Convention on Human Rights, they would have signed up to it. And they have not done so. And insofar as the Inter-American Commission is suggesting otherwise in the Edwards case, it's wrong. But in fact, I'm not sure that it is going quite as far as that. It talks about that there's something of a, for anyone who's looking at this with a sort of sceptical eye about far-fetched human rights arguments, there's something of a klaxon in the way the wording talks about this supplying the context for those rights. What it doesn't do in my submission is to positively say, even in Edwards at its highest, say that you must, as it were, read the rights in the Convention into the Declaration. And why would you? I mean, it would make a mockery of the rule of international law.
Well, clearly that would, but I thought the point was a more modest one, that where you've got in the Declaration you can't discriminate in terms of any other factor. You could look to see that it does say in the Convention that nobody must be discriminated against on grounds of their illegitimacy. And that's a relevant consideration when you're deciding how to interpret the breadth of any other factor.
Well, in my submission, my lord, it's not, because the Bahamas didn't agree to it. This is, it's in my submission, it's fundamental that one doesn't, even at the international level, let alone the question of how these sound in domestic law, including domestic constitutional law, one can't impose obligations on a state on the basis that a treaty to which it didn't sign up refers to certain specific rights, which are not mentioned explicitly in the treaty to which it did sign up. I mean, I accept that my friend's entitled to point to the American Declaration and say, that refers to non-discrimination on various factors or any other factor. But it would be a very strong thing in my submission to say, well, that can simply override the proper interpretation of the Constitution, if I'm right about the proper interpretation of the Constitution. And I do go, I mean, there is clearly I would submit something of a tension between what I accept is the established position that when construing constitutional, or when construing domestic law, including constitutional law, the court will, where it can, adopt a construction which is consistent with the state's international obligations. And the observations of the Supreme Court in the SC case about the limited role of international law. The Supreme Court expressly ruled out in the passages I showed the board before the short adjournment the idea that the court could itself rule on the compliance or otherwise of the United Kingdom with international conventions to which it signed up. So in my submission, one is on somewhat shaky ground, putting it mildly, in saying, well, you can interpret a 1973 constitution on the basis that if its meaning was the objectionable meaning to start with, nevertheless it should now be seen to have been changed because of the 1981 accession by the government on behalf of the state to an international convention. That my submission does present some significant issues as regards the rule of law and the proper separation between the role of the judiciary and the role of the legislature and the role of the executive. So in my submission, I submit that's not a promising way to go. But in any event, even if one does look at the American Declaration, the provisions of the American Declaration which are most relevant are, of course, those which deal expressly with the question of nationality. If it had been intended by the signatories to the American Declaration to say that your right to nationality shall be conferred without discrimination on the ground of your parents' marital status, then that could have been said, but it doesn't say that. It says in Article 19, simply, you have the right to the nationality to which you're entitled by law. That's page 400 of our additional submissions. I didn't put it in, but I did look at the travaux preparatoires of the American Declaration, which in fact say explicitly that it was as a result of some discussions between the states, or potential states parties, and difficulties in finding a definition, that they settled on a very limited right to nationality. I can supply the document if it would assist. That Article 19, that's the lex specialis of this treaty that deals with nationality. And in my submission, it would be quite wrong for the board to, as it were, to outflank Article 19 by saying, well, yes, but look at the general provision about non-discrimination in Article 2, and then to say, well, look at any other factor. And it doesn't work as a matter of textual interpretation anyway, in fact, because if one looks at Article 2, it's all persons are equal before the law and have the rights and duties established in this declaration without distinction as to race, sex, language, creed, or any other factor. Well, that, again, just goes back to the question, what are the rights established in this declaration? So all of that, in my respectful submission, is something of a red herring, and the real issue is not one of evolving understanding of the meaning of Chapter 2 of the Constitution, or understanding that can be changed because of an evolved or new way of looking at things that gives contemporary effect to fundamental rights or to international materials. The answer is simply, what's the proper construction of Article 1 in the Constitution? And can I then, after that rather lengthy attempt to clear other questions out of the way, come back and deal with that question directly? As I said earlier, I accept that it goes too far to say, and indeed it would be wrong to say, that in the eyes of the Constitution, a person born to an unmarried woman has no parents. And there are two reasons I say that. One is that would, of course, have the unacceptable result that a person born in the Bahamas to a woman who was a natural-born Bahamian citizen by a man who was a natural-born Bahamian citizen would be stateless. So I accept that can't be right. But the other reason why it doesn't work is Article 14.1 itself. If one turns that up, it's page 563. any reference in this chapter to the father of a person, I know we've read this several times, but it's worth reiterating it, shall in relation to a person born out of wedlock, other than a person legitimated before the 10th of July 73, be construed as a reference to the mother of that person. That, of course, doesn't work if the absolutely fundamentalist, as it were, approach of the common law is taken, because a person born out of wedlock doesn't have a mother either, in the eyes of the law, because the person is the son of neither. And of course, you're a son of both a mother and a father. So
another objection is it makes you worse off to be born in the Bahamas than to be born outside it.
Well, that may be right, my lord. But let me, having established that, having as it were, conceded that.
I just wondered what the concession was, because if you go back to Article 6, every person born in the Bahamas at the date of his birth shall become a citizen. That's a child. And so you're accepting that the Galloway against Galloway principle, the Fisher principle, doesn't apply to that part of Article 6.
It doesn't apply in the full rigour of the common law. It doesn't, under the Constitution, apply in the full rigour of the common law sense that a person born to an unmarried woman has no parents. That much I accept. But can I just develop what I do mean by?
Then if you're accepting that the principle doesn't apply in whatever limited sense it is, and I frankly at the moment I can't quite grasp the concept. But if you say it doesn't apply, then why should it apply at all?
Well, let me explain why I say that, my lord. Because and it's really this. Although it is the case, as I say, that it doesn't apply to that extent, one does yet have this point that, and this point that jumps out of chapter 2 all through it. It is suffused with the notion that there is a valid distinction to which the law should pay attention between legitimate and illegitimate children. It's replete with references to that. So it's
well, actually, I take as a point against you, because it shows that when the legislature or the constitutional drafters wanted to deal with make legitimacy relevant, then they put it in the provision.
Well, my lord.
And when they don't, then they don't.
Well, my lord,
what I'd like to know is how, on your interpretation, why, on your interpretation, are 6 and 7 drafted differently from 8 and 9? Why has the drafter used different language to achieve what it seems to me, on your case, to be exactly the same result?
My lord.
Or is there a difference? What is the difference between them on your case?
I would respectfully turn the point round and say that it places far too much weight on the particular choice of words to say, oh, that has a distinct consequence.
No, but surely if they wanted to confer identical rights on people born inside and outside the Bahamas, they would have used the same language.
Well, my lord,
they've deliberately, as it seems to me, introduced legitimacy in 8 and 9, but not in 6 and 7. And so unless there's some other distinction between them at the moment, that seems to me the only distinction.
The answer, my lord, is it's in Article 14. But if can I develop the submission this way and explain why I say it? Well, if one starts with if one steps back first of all and looks at the overall scheme, and I entirely accept. I think it was Lord Legate's point, my lord, that you have to come up with a coherent scheme, or you have to assume at least that the Constitution's framers intended to develop a scheme that was to enact a scheme that was coherent. But if one starts with Articles 8 and 9, citizenship by descent, that provides pretty clearly, well, you get citizenship by descent if you're born outside the country. Article 8.2, and your father is a citizen of the Bahamas, unless, of course, you're born out of wedlock. Because if you're born out of wedlock, then Article 14 applies, because it says any reference in this chapter to the father of a person shall, in relation to any person born out of wedlock, leaving out the qualification there, be construed as a reference to the mother of that person.
I see. So you say there is a difference because in 6 it's the mother as well as the father for legitimate children. Is that right?
Well, not precisely. But let me, so far as and then Article 9 goes on to say as you see, that a person born legitimately, again emphasising the framers' preoccupation with legitimacy, outside the Bahamas, whose mother is a citizen, is also entitled to citizenship, but only upon attaining the age of 18 years.
In fact, I think you say that's exactly the effect of 6 and 7 for people born inside the Bahamas, isn't it, on your interpretation? It's exactly the same.
My Lord, essentially, yes, it is. And I know your Lordship is about to say, well, why do they use different words? And I'll come on and do that in a second. But if we just turn, when we turn to Article 6 and persons born in the country, we get this provision, either of his parents. The way I would respectfully put it is this: does that mean wholly irrespective of marital status? Well, I would respectfully submit. I suppose it's conceivable it could, but it's a bit unlikely in my submission, bearing in mind the preoccupation that we've seen throughout the rest of Chapter 2 with the notion of legitimacy versus illegitimacy. There's another aspect of context which is possibly significant here, and that is the statutory provisions as they were in the United Kingdom in 1948 and as they then became in 1981. And I think it's probably an omission on our part not to have put them before the board, but we can do that. But we're in agreement about the effect of them. Under the 48 Act, as we've said, I think there was no need to make any provision about what happened if you were who your parents needed to be if you were born in the United Kingdom or colonies, because the mere fact that you happened to be there when you were born made you a citizen, just like the contemporary position in the United States, or position has always been in the United States. So there was no need to address that issue. But as regards people born overseas, in other words, outside the UK and colonies, you became a citizen of the United Kingdom and colonies if your father was a citizen of the United Kingdom and colonies. That was altered in 1981 in the UK, and I accept, of course, that's after this constitution that we're concerned with, but it's striking that the prevailing preoccupation with legitimacy versus illegitimacy was still there. And what that provided was that you could, that of course meant that did away with the notion, the jus soli notion that you got it by virtue of birth on the territory of the UK and colonies, or UK and overseas territories by that time, by then was, and replaced it with a provision that did depend upon your parentage. And it said that if it was your mother or your father who was a British citizen, then you became a British citizen if you were born in the United Kingdom. And it went on to provide in Section 50 that for the purposes of the Act, an unmarried mother is treated as the mother of her child, but an unmarried father is not.
So an unmarried mother was treated as what?
Unmarried mother is treated as the parent of a child. Unmarried father is not. So that is I do submit that's part of the context. It's difficult looking at it sort of 50 years later, perhaps, to get into the mindset that was prevalent there. But the British Nationality Act illustrates that was, even as late as 1981, that was the prevailing wisdom. And indeed, as we've seen, that wasn't changed until 2006, I think, in the United Kingdom. So is it what in that context is meant by either of his parents? And by that context, I mean, one, the prevailing preoccupation in Chapter 2 with legitimacy versus illegitimacy, which keeps cropping up, and two, the British context. What were the framers of the Bahamian Constitution trying to do in Article 6? Were they striking out in a different direction and saying, actually, legitimacy of your parents doesn't matter for these purposes, or were they seeking to do something different? And in my submission, the better interpretation actually is that if they were seeking to do something different, they would have spelled it out in quite clear terms, because the prevailing assumption of Chapter 2, in all other respects we can see, is that legitimacy, far from being some archaic and irrelevant factor, which it's positively offensive to take into account, is an important consideration, because that's how the people who were legislating at that time thought, just how the United Kingdom thought in 1981 and carried on thinking until 2006, albeit I accept that legislative changes lag behind social changes sometimes. But that was the mindset there. That's the context of my submission in which one needs to look at what's meant by the expression either of his parents. And
in a sense, the legislative background in the United Kingdom and in Bermuda was the same, because
in the Bahamas, yes.
Bahamas, sorry.
Yes.
I can't believe that's wrong. Because in the Bahamas, it didn't matter whether you were legitimate or illegitimate. Prior to 1973, so long as you were born in the state, there you are. And the same applied in the United Kingdom. And if you wanted to change that, you spelt it out. In the United Kingdom, they spelt it out in the 1981 Act and then in the 2006 Act. And
yes, I'm grateful that Lordship's raised that point, because I meant to come back to that, and I'll deal with it now. It is an important consideration, but it's not. I can see that, of course, there is a general argument that one can raise in lots of contexts that says, well, if you're going to do something which has the effect of taking rights that are already there away, then you're expected to do it in fairly express terms. That's not the position here. The reason, the difficulty that faced both the United Kingdom and the Bahamas on independence, the United Kingdom faced it in 1981 and the Bahamas did it earlier in 73 on independence, is once we've taken the decision to move away from a system that depends upon birth on our soil, what do we replace it with? And the fact that you replace it with something more restrictive doesn't in itself tell you anything about how you should read the new system, how you should interpret the new system. On any of it, it's bound to be more restrictive, because the old system was such that you could be, as people sometimes were, you could be born somewhere and have citizenship of a country simply because you happen to be there because your parents were there for their jobs. That's why at least one former prime minister of this country had American citizenship by birth, and it happens sometimes. It's obviously it can be exploited and abused, and it happens sometimes accidentally. But it's a somewhat in the modern world of I mean, it may have made sense in the days when people didn't tend to much. In the modern world, where people are flying around all over the place, or at least those who are lucky enough to afford it are, of the world's population, it makes sense to do away with that way of doing things. It doesn't really tell you very much in my submission about how you should read the scheme that the framers of the Constitution.
So your submission is you're not taking away rights as such, because it's not retrospective. People who've got the rights pre-1973 retain those rights.
Yeah.
You're now in a new world.
Yes.
And therefore you can't directly say that rights have been taken away.
Precisely.
Yeah.
Precisely. And indeed, and you see that in the scheme of Chapter 2, because Article 3, which translates your UKPC citizenship into Bahamian citizenship, doesn't say, by the way, that doesn't apply if you were not descended from a citizen of the United Kingdom and colonies. You could have been somebody who was working in the Bahamas, or whose parents rather were working in the Bahamas and had nothing to do with the place, but you were born there, so you picked up citizenship that way. So it's not precisely. It's not taking away any existing rights. It's saying that now we need to start again. Now we've decided to move away from citizenship based upon presence on the territory. We need to devise a new scheme. What scheme shall we devise? And what assumptions, and when construing it, what are the prevailing assumptions about how it works? And a strong prevailing assumption, in my submission, would be that when you talk about who a person's parents are, it certainly doesn't include the father of an illegitimate child. And I would venture to submit that if one applied a sort of officious bystander test to this at the time, what would the framers have said if somebody had said to them, "Are you intending to bring in the fathers of illegitimate children?" By that phrase, they would have said, "Of course not. Of course not. Why on earth would we do that? That would be entirely unacceptable. Look at all the rest of our provisions."
So can I just be clear? So the revised submission, as I understand it, you are really abandoning. I think what was your main point before was that we must go back to Galloway and Fisher.
Yes,
and you're actually now effectively saying, as I understand it, that we just have to read, given the context in which this constitution was being drafted, that an unmarried mother counts as a parent and an unmarried father does not count as a father.
Well, that's
and
right.
To the extent that that was just commonly understood, that's what you're basing it on, rather than any common law concept that at one time illegitimate children just didn't count as children, parents of illegitimate children didn't count as parents.
Yes,
Am I right in understanding
that's right. I mean, the reason I put my submission initially as high as I did, and I think on reflection wrongly, because your lordship's gentle probing in the course of my submissions this morning has identified some difficulties in it, was really to make the point which I'd still stand by, which is that once you have established what the understanding was in 1973, what they would have meant in 1973 by this, you can't then undermine it by saying, well, by doing any of it. I think essentially the three things that our learned friend submissions do, if they're wrong on the primary point of construction, which is one, to say, well, times have changed, two, to say, look at the other parts of the Constitution, and three, to say, look at international obligations. Because none of that stuff bites on a provision like this. Because this is why I come back to my point about this having a precise meaning rather than being something that just invites future generation of judges to put flesh on the bones.
So could you help me as to how you now formulate your case?
Yes. I say, my lord, that either of his parents in Article 6, read in the way that one reads any legal instrument, and that is neither generously and purposively, but nor, I emphasize, narrowly and technically, but simply on the basis of objectively what from the language one can discern the draft has meant. Either of his parents means mother or mother's husband if the mother is married. And I get that both from the context I've mentioned, but also, and this is where I need to turn to it, also from Article 14. What's been said against us...
I do apologise.
Not at all.
You're not relying upon any common law presumption. You're relying upon objectively the language, which is Article 14. Context?
What is the context? Where do you get it from, other than from some extraneous legal presumption or from Article 14?
The context, I get from the fact that one can see in the development of the law as regards citizenship and nationality that whereas and indeed the law generally as regards the issue of legitimacy versus illegitimacy, whereas at the one end of the spectrum, temporal spectrum, historically, the common law had taken this absolutist view that you were just a non-person if your parents weren't married. That had been mitigated to some extent, and we see that in the fact that one in the British Nationality Act 48, one was not stateless if one's mother was unmarried. But temporarily, by 1973, there had been no understanding at that point that you would get, in any British context, citizenship simply on the basis of being the child of an unmarried father who was a national. And
so do you say Article 14 was in fact unnecessary because even without it on your approach, it just wouldn't have been read, shouldn't be read?
It probably wouldn't have been read that way, but it confirms the position, and this is the point I want to make about Article 14. Hitherto, I think the way it's been put, and it was put like this in the courts below, Article 14 has been read as if it says every time you see the word father, that must mean mother. That's not what it says. What it actually says, as you see, is any reference in this chapter to the father of a person. One has to, and it's a small point, but it's an important point in my submission of drafting. It's a reference to a father. You have to see a reference to father. It doesn't say a direct reference. It doesn't say any use of the word father. It says simply the father. And there's a distinction in the drafting technique, which is between that and the way in which, on numerous occasions in this Constitution, the drafter has given a particular word when it appears a particular meaning. And we can see that, for example, at page 575 in Article 25 of the Constitution, towards the bottom of page 575. Article 25, paragraph 4, for the purposes of subparagraph C of paragraph 2 of this article, law, in inverted commas, in that paragraph includes.
Sorry, bear with me a moment.
Of course. .4 on page 575, yeah. The point is the drafting technique, law in inverted commas. Where you see that word, this is what it means, in other words. And similarly, over the page, 576, down to the next page, discriminatory in inverted commas.
Sorry, where
576, what
Right at the top of 576, the first line of 576. In this article, the expression discriminatory means. And you haven't got the rest of...
So you're
I'm not clear what submission you're making at the moment. You're saying wherever there's a reference to the father.
What I'm saying is the way in which it's been interpreted, the way in which it was interpreted in the first instance, I think, is to say, well, look at Article 6. It doesn't refer to father. It doesn't say the word father.
You're saying it doesn't
parents.
say whenever the word father is used, and a reference here can mean an implied reference.
Yes, my lord, precisely.
Even though it hasn't used the word father, it can still refer to the father by using words that lead you to that term.
Yes, that's right. And the distinction as to the drafting technique is, as I say, is the one I draw, where you, and I've given you two examples. You haven't got the rest of the Constitution in the materials, and we can supply it, or it's obviously readily available. But what one will see that the Constitution is full of references like the ones I just showed you, where it says reference to, in inverted commas, such and such a word means such and such a thing. That's not what's done in Article 14. What's done in Article 14 is, as we see any reference in this chapter to the father of a person. Well, what about Article 6? Article 6. Well, I submit the question is, to whom does Article 6 refer? Article 6 refers to either of his parents. It's a reference to the person's mother or the person's father. How do we interpret those terms if they need interpreting? Does it mean just biological father, if it's the father? Well, that can't be right, because Article 14 says, no, a reference to a father in relation to any person born out of wedlock is a reference to the mother. Now, this was seized upon, I think, by the now Chief Justice in his judgment to say, well, that's absurd, because if you textually translate either of his parents into mother or father, then applying Article 14, you'd have to read that as a reference to mother or mother. But that's in my submission, actually, that runs into precisely the objection that my learned friend makes time and again to legalistic and formulaic ways of reading statute. That's far removed from the real task at hand, which is simply to say, as a matter of the construction of the expression, looking at everything that we know about the context, which, as I say, includes both UK law on this point and the other provisions of Chapter 2 and Article 14, what's meant by either of his parents? And the answer is that if one reads it consistently with Article 14, it can't mean either his mother or his father, irrespective of the latter's marital status.
So, as I understand it, you would say that 14.1, we have to in effect read any reference, open brackets, direct or indirect, close brackets, in this chapter to the father of a person. That's the interpretation you really wanted to give it. Is that right?
Well, sort of yes and no, my lord. Yes, in the sense that I suppose that's the broad way of looking at it. But if there's a sort of silent premise that it has to have that qualification in order to have that effect, then of course I don't accept that. Any reference, any reference.
Yeah.
Well, why does it go about it in this complicated way? Because by saying that you read father as if it read mother, the simpler way would have been the way they did it in the Nationality Act, which would be to say that where it says parent, you don't include the father if the child is illegitimate. You don't need to put the mother in, adopt a drafting technique of putting the mother in again.
Well, I agree it's done slightly differently. I'm not sure your lordship's summary of the Nationality Act is precisely how it's put, but that's our fault for not having put the document in front of the board.
Well, it says parent in relation to an illegitimate child should not include a putative father. So maybe.
You're talking about. Forgive me. You're talking about the Bahamas Nationality Act.
Yes.
So I thought you were talking about the British nationality provisions in their original form.
Just as a drafting technique, it's a very odd way to go. If you want to exclude the illegitimate father for an illegitimate child, why don't you just say that? Why do you instead substitute an additional OTO's reference to the mother for a second time?
Because what's being sought to be done in Article 14 is to underscore, the significance of being born out of wedlock, and secondly to provide that in relation to a person whose father was not married to their mother, there is notwithstanding the impossibility of deriving any advantage from that sort of father, as it were, a way in which citizenship can be conferred, namely through the mother. I mean, this is a question. It does rather depend upon how one comes at it. If one looks at this with the eyes of a modern person in 2023, looking at this in the context of this, saying, well, this obsession with legitimacy versus illegitimacy is all rather archaic, then one can see that the construction that our own friends contend for is more appealing. But if one puts oneself in the mindset of those who are clearly, I submit from the rest of Chapter 2, one can see, very much alive to the importance of the distinction, then the idea that there is some great weight to be placed upon the choice of the words either of his parents as opposed to father or mother is pretty fanciful in my respectful submission. At any rate, it's not tenable.
Absolutely, certainly I understand your submission. You rely upon a textual analysis of the Constitution. You do not rely upon any presumption, Galloway against Galloway or Fisher. I mean, you've already said this to
yes,
Lord Burrows, but I wanted to be absolutely certain that part of your argument is no longer to...
I don't rely... Yes, I don't rely upon a textual presumption as to the meaning of... I don't say that the common law meaning of the word parents is applicable in this Constitution. I can't say that, because if that's shown to be wrong for the two reasons I gave earlier. One, it would result in statelessness in the case of those born to unmarried Bahamian citizens, and two, it's inconsistent with Article 14 itself, which
let me just chase it down a little bit, because you don't rely upon the common law presumption about parents. You don't rely it also in relation to the common law presumption about children.
Well, the two are
that's fine.
Yeah.
Okay, that's fine. That's okay.
But although I don't rely upon a common law presumption, so as to say, when the drafters of Article 6 said parents, they meant only those who are the offspring of married persons. Although I don't go that far, and I can't go that far for the two reasons I've indicated, that doesn't immediately chuck out the relevance of all notions of legitimacy versus illegitimacy. That's still there as something which the law regards as significant, and that we can see that from all the other provisions which place emphasis on the marital or other status of the persons concerned. In particular, Articles 8 and 9 and 14.
Are there any others apart from those? Just just so we have a complete picture.
Well, yes, there is. There's Article 3.2, which references father, and therefore that again brings in Article 14, but it's not an independent reference. Article 5 entitles a woman who's married to a person who becomes a citizen by virtue of Article 3, i.e. a natural-born British subject who becomes a Bahamian at independence. But I note that the emphasis there is on marriage to a person. It doesn't say, and it would be extraordinary looking at it from a historical lens if it said married or in a relationship or akin to marriage or married or the partner of. Indeed, if the language of partner would have been incomprehensible in 1973. They'd have said, what do you mean they're in business together? It would just was that sense of the word simply didn't exist. So I think those are the provisions. But in that context, to say, well, because it says either of his parents rather than father or mother, it must be that what they were signalling was an intention to extend Bahamian, or not to extend, but to confer Bahamian natural-born Bahamian citizenship on anybody who was born to a Bahamian citizen, irrespective of marital status of the parents. It is simply wrong in my submission. It's just an entirely ahistorical way of reading the document. And if I'm right about that, then I submit that this is not one of the. This is why I make the point that I took you to Oakley and made the overall point, and Chandler the overall point about provisions that are susceptible to updating and those that aren't. Then, if I'm right about that, then what we have is, however much one might with modern eyes object to it, a provision which is clear and express in its terms, and which is therefore not amenable to be updated merely because social attitudes have changed. The way in which to effect that change is the way in which the Parliament of the Bahamas decided it wanted to make that change, namely by amending the Constitution, amending Article 14. And its understanding of Article 14, as evidenced in the bill that went to the referendum, the Constitution Amendment Number 3 Bill of 2014, its understanding is clearly to the effect, I submit, that there is no distinction between persons born inside the Bahamas and persons born outside the Bahamas. They're both in the category of persons who get citizenship in one way. If they want to get citizenship from their fathers, it depends upon their parents having been married. And we saw that from the way in which the referendum bill, as it were, was expressed.
But you would accept it. It could be a rational purpose to distinguish between children born within the Bahamas, whether legitimate or illegitimate, and children born outside the Bahamas. That would be a rational purpose. I mean, you can't say that the counter-interpretation to the one you're taking is irrational. You may say it's equal both ways, but I don't think you can say it's irrational, can you? Particularly as that was, of course, the position as we know beforehand. Well,
except, my Lord, I come back to our discussion earlier. I mean, the position beforehand is beside the point in my submission, because that was just a totally different system.
Okay.
That took no account of. In other words, you're a citizen if born on our soil, which simply took no account, didn't care who your parents were. That's a completely different system. And so what we're looking at really is when the framers of the Bahamian Constitution came to set out what they thought the law should be in a post-independence world, where they could have said any person born on the soil of the Bahamas is a citizen after independence. They didn't do that. They decided to move away and to come up with a scheme which made different provision. And I do say it would have been irrational to say that this matters if you're born outside the Bahamas, but not if you're born inside the Bahamas. if you're because they're devising a scheme from scratch as regards people inside the Bahamas.
But isn't it? Wouldn't it be surprising if, given the background, that it's the father's inheritance which counts for citizenship? That's how it was before, wasn't it? And that's how it is carried over for people born outside.
People born outside.
Your mother doesn't count for anything. It's only your father. And then, if you're illegitimate, it's otherwise. Why go from that to a scheme where the mother now does count for people born inside the Bahamas, but it's better. You get more advantageous rights through the mother, as it were, than you do through the patrilineal line. Or is that not the case on your?
No. Well. Yes.
I mean, if you're illegitimate, you're.
Yes, I see your Lordship's point, but I'm not sure that doesn't. I mean, to come back to answer, if I may, Lord, I appreciate time's up, I think, but to answer Lord Burroughs' question, if I may, on the I've started so I'll finish basis, if I may, I don't need to go as far as to say that it would be irrational. I do say it would be pretty odd to draw that distinction, but I don't need to go as far as to say that. My essential point is as I hope your Lordships have, however inelegantly I've succeeded in expressing it, is that it would actually, as a matter of construction, be very surprising if they had intended in 1973 to strike out in a different direction and say that as regards people born in the Bahamas, parentage, whether you're born of married parents, doesn't matter. But at the same time, to say as regards people outside the Bahamas, it matters a great deal. I mean, you could understand it if they decided to ditch the importance of, if they thought that it actually wasn't important whether your parents were married, they'd have done that as regards people born inside or outside the Bahamas.
But, I mean, the people born inside the Bahamas obtain citizenship through territory and descent. And people born outside the Bahamas are judged on different factors, namely descent.
But it would be rather surprising if, given that they're in 1973 they're devising a new scheme to replace territorial citizenship.
They made it slightly.
It'd be rather odd if they said, well, as regards people outside born outside the Bahamas, legitimacy matters a great deal, and that's why we've got all these provisions to deal with it. And it's quite an elaborate scheme. If you get it through your father, unless your parents aren't married, in which case you get it through your mother, and you can also, if you're born legitimately outside the Bahamas, get it through your mother upon attaining 18 years. So actually, I should put that in a different order. You get it through your father, Article 8, get it through your mother at the age of 18 years if you want Article 9, but see Article 14 if you're illegitimate. To do that, and at the same time to say it really doesn't matter at all if you're born in the Bahamas, would actually have been a rather surprising thing to do, and they would have used clear language to do it. And the only textual basis for saying that that's what they did is that they, instead of saying mother or father, they said either of his parents. And in my submission, that those words can't bear the weight that the learned judge and the majority in the Court of Appeal put on it. My Lord, I think, unless your Lordships have further questions which you're willing to go into extra time to make me answer, I think that's what I wish to say by way of reply.
Thank you very much, Mr. Rowe. Mr. Fitzgerald, we're very grateful to you for the most interesting submissions we've had throughout the course of the day. We're also very grateful to those sitting alongside you and to those behind for the very hard work that's gone into the preparation of this important case. The board will take time to consider what advice we will, in due course, humbly tender to His Majesty.